Around 55,000 new applications are made each year in private law proceedings. These cases can be extremely complex and may include serious allegations of sexual assault, physical harm, psychological manipulation, and financial exploitation. Yet in only 15% of cases are both parties legally represented, and in a staggering 50%, neither party has legal representation. This is part one of a two-part podcast exploring how the family courts treat allegations of domestic abuse in private law proceedings. In this part, we discuss the scale of the issue, the low status of domestic abuse, and how parties, CAFCAS, lawyers, and our courts are struggling to deal with complex and serious allegations of abuse in an underfunded and under-resourced family justice system. Welcome to Control and the Law, the podcast about coercive control and stalking from a legal perspective. Today we are discussing how allegations of domestic abuse raised in private law proceedings are being addressed by the family courts. I'm Sarah Ellis, barrister, and I'm joined by Professor Rosemary Hunter, Honorary King's Counsel from Loughborough University. Rosemary is a leading international socio-legal scholar and is a co-author of the influential Harm Report of 2020 and more recently the Everyday-Business Report commissioned by Nicole Jacobs, the Domestic Abuse Commissioner, and focusing on how domestic abuse is addressed in the family courts. My second guest is Professor Jo Delahunty KC of 4 Paper Buildings Chambers in London. Jo is recognised as a leading family silk by the Legal 500 and has been the recipient of many awards, the most recent being LexisNexis Family KC of the Year in 2025. Jo is also a co-author of a forthcoming book called Domestic Abuse and the Family Justice System, which is due to be released in February 2026. So thank you both for coming on the podcast and agreeing to discuss this somewhat thorny issue. And Jo, can I start off by asking you to define what private law proceedings are in the family courts?
I think we in the legal profession assume too much knowledge in the public or indeed our colleagues. So I'm going to use the one which makes most sense to me, and it's a distinction between private family law and public family law. I use public family law to define the term where the state, the public authority, intervenes in a private right to family life. So, for example, a local authority will take an emergency protection order or want to take children into care or a child into care. What I mean by public law, because it's when the state, the government, interferes in what otherwise is a private domestic scenario. Private law, therefore, I use to refer to a dispute within the family, between partners in relation to a child. That doesn't mean to say that a private law can't become a public law scenario, but I think for the purpose of this distinction, when we're talking about coercive controlling behaviour, private law, a dispute between parents, is probably where the primary discussion point is going to be.
And let's talk briefly about the scale of the issue. So, Rosemary, in your recent report, Everyday Business, what figures did you find in terms of the number of allegations that are being raised of domestic abuse?
So we used 2 different methodologies for understanding what was going on in the courts. One was looking at case files, which obviously gives you the whole picture of the file from beginning to end. And the other was sitting in the courtroom observing the cases, which obviously just gives you a snapshot of the case. So in our snapshot observations, we saw that it was evident to us as observers that there was domestic abuse involved in 73% of the cases that we sat in on, of the private law cases. When we looked at the case files, which obviously, as I said, beginning to end, you would expect a higher proportion because not everything will be evident in a single hearing, we found that 87% of those case files included issues of domestic abuse. So domestic abuse was raised as an issue in 87% of those cases. And that's why we ended up calling our report Everyday Business, because domestic abuse is the everyday business of the family courts in private law proceedings.
The official figures, I think, are a bit lower. In ReHN, I think the President referred to around 40% of cases involving.
It's really important to understand that there aren't any official figures.
Right.
Current family court administrative system does not have any mechanism for recording whether domestic abuse is raised in a case. So the only evidence that we have is from previous studies that have done similar things, that have looked at files. And in those previous studies, they've found somewhere between 49 and 62%. And I think there's a reason why our findings were higher. And I think that I would defend our findings as accurate. There's several reasons for that. One is that there's much greater awareness about domestic abuse now than when previous studies were done. All of the previous studies predate the Domestic Abuse Act. And so there's much greater awareness both of the range of different kinds of abuse and the sort of willingness to raise it. Secondly, I think that because after LASPO, the enormous increase in litigants in person in the family courts means I think that lawyers sometimes filter out domestic abuse. They don't necessarily raise it in the case because, they're going to deal with it elsewhere, or they know that there's little point raising it in the court because it might not be dealt with appropriately. Whereas I don't think litigants in person don't have the same filter. And so again, I think it's more likely to be raised. And we also have a much broader understanding of domestic abuse now than it was the case when previous studies were undertaken. So we classified domestic abuse as being raised where either the parties, the CAFCAS, there was some other evidence that something falling within the definition of Section 1 of the Domestic Abuse Act had occurred in that family. And that's the figure that we came up with. And I think that that's an accurate figure.
I agree with Rosemary. I was struck, I don't know if Rosemary was, by the contents of the President's speech to ALC, which was delivered in November, because in that speech he compared Rosemary's analysis with the figures that the government are working on, indeed he was working on, which have been published by CAFCAS. And I'm just reading out here, a file MP said of the statistics, those figures, Rosemary's, are strikingly different to the national data for England produced by CAFCAS, which put the average degree to which domestic abuse was alleged in private law proceedings at 60% in cases. And the more general working assumption that I have had of the issue is raised in 2/3. Now, I agree with Rosemary's approach. I think our recording ability historically has been very poor. Our listening ability has been even poorer. And what was so illuminating about the Everyday Matters report was it went to the grassroots and it spoke to people. And I think that was why, out of many aspects of the report for me, it brought home just how prevalent this issue is, and still the degree to which we don't see it. It's happening in plain sight. So for my part, in the forthcoming book, I particularly allude to Rosemary's statistics and support them for all the reasons she's identified.
But one of the things that we found was that there's no single reliable source of evidence about the presence of domestic abuse, and that even CAFCAS undercounted. So CAFCAS safeguarding reports had the sort of highest proportion of mentions of domestic abuse, but in the files, they missed about almost 20% of cases where domestic abuse was actually raised. So, for example, there might be something that is raised in the C1A form, but CAFCAS don't mention it in their safeguarding report, or it's not mentioned early in the case, but it is raised at a later stage in the proceedings. For example, in one of the parties' statements or a position statement, so that, there's a number of ways in which it could come up. But there was no single reliable source of evidence in the case files.
Is that one of the conclusions of the Everyday Business report, that the system is too sort of disparate in terms of there's no single document in which you can put down your allegations of domestic abuse in a kind of comprehensive way?
I mean, so there really needs to be much more official attention paid, and one of the sets of recommendations that we made was about data and data recording and how that should be done, and how it needs to be done much more systematically than is currently the case.
I just want to turn to the status of private law proceedings and the status of domestic abuse. And this is one of the observations made by Professor Evan Stark. If we're serious about reducing domestic abuse, we need to raise the status of it. And from your perspective, Jo, within the legal profession, what is the status of private law proceedings? Is it seen as a bit of a poor relation to public law proceedings, or is the complexity of the work, because it can be incredibly complex in private law proceedings, and yet is it seen in that way?
I don't think so. I think it's also, one, there's a division between private law and public law. The concept used to be that when you started off at the bar, you might start off doing domestic violence injunctions, and from that you progress to doing private law disputes about contact. And then once you acquired that type of learning and you were focusing on the rights and activities of children, then you move into public law, because of course the consequences of public law at its most extreme are adoption. And as Sir James Mumby, so recently deceased, and friend, colleague and mentor, told us in many a case, since the abolition of the death penalty, adoption is the most extreme degree of state intervention you can have in a family. And I think by comparison with that, private law is seen as something which is easily resolvable because at least the child is within the family. For me, it's not even the distinction between private law and public law. It's the distinctions within private law about what resources you have available to you, both in order to fund your litigation and what resources there are in terms of court. If, like me, you have chosen, since having your worldview exploded by a case, in my case it was re-HN in the Court of Appeal, and you have then chosen to sit in private law deliberately at the front line in order to see what goes on, then it is a Wild West. When I'm appearing in court, I feel grateful if I have a representative, a legal representative in front of me. Although now we've gone beyond unrepresented litigants turning up with carrier bags full of documents, what they don't bring in paper is cluttering their head. And they're in an alien system, in an intimidating system, where their capacity to form a chronology or construct their case is highly limited, not just by the perceived hostility of the working world. It's a very alien system to walk into, but also by the emotional context. So how they get their narrative across depends on skilled, sensitive advisors who are properly trained. And there are so many barriers to the narrative being spoken of, understood and then relayed, that I worry that we, even when in court, we're not properly digging down into the reality of the child's experience and the victim's experience. And for that, as I say, when I use the terminology Wild West, it's because it's so unreliable in terms of understanding what's going to cross your path, hour by hour, let alone day by day.
Yeah, I agree with Jo in the sense that there's a kind of residual notion that private law disputes are just bickering adults who, ought to be able to sort out the issues with their children by themselves. And if they can't, they just need a bit of hand-holding or encouragement to, put their disputes aside and get on with it. And that's just not the case anymore. If it ever was, it certainly isn't now. With the complexity of the issues that are being brought to court, with this very high level of domestic abuse, very high level of litigants in person, but at the same time, really major resource constraints on the judicial and court resources that are available to the court. And those two things just make a perfect storm.
And just to interject here, if we could just emphasise the seriousness of the issues we're talking about. I regularly, when I sit, deal with allegations of full rape, anal rape, oral rape, attempted strangulation, stalking, harassment, allegations which in any other sphere other than the private family world will both warrant trained prosecutors, if one were bringing the allegations, for example, or might warrant silk being instructed in a public law realm. I mean, attempted strangulation, we know what the figures are in terms of that being a precursor to actual death. Rape, it's difficult to conceive of a more emotionally and physically traumatic experience than rape, and we shouldn't be gendered and assuming that it's just male upon female. There is an underreported degree of same-sex sexually coercive behaviours. And yet in the family courts, those allegations are regularly dealt with by very, very junior counsel, if there is luck in counsel being instructed at all, because the legal aid rates of pay are so poor that it's relatively rare to get someone senior doing it, unless, for the likes of myself and my colleagues, we choose to do it pro bono, because we believe those issues are so serious when we're acting as advocates. So I am forever astonished and concerned about the gravity of the allegations we deal with as of norm in private family law, that because of the word domestic in front of them, I feel they're almost trivialised. If we just talked about abuse in the way we do in public law, would we view those allegations with the same degree of almost familiarity, such that it's standard behaviour? It shouldn't be standard behaviour. I'm not for one moment suggesting it is, but just feel the terminology, we've still got a hangover from the past in terms of thinking of domestic as something that is less serious because it doesn't happen to a stranger.
If we just talk about representation, because the lack of legal representation is a fundamental problem within private law proceedings. So we had LASPO 2012. LASPO is the Legal Aid Sentencing Punishment of Offenders Act. It decimated civil legal aid. It's withdrawn legal aid from so many people, but particularly in private family proceedings, also housing, and it's created legal aid deserts across the country where people just cannot get any legal advice. And as a result, and these are the latest government statistics for the last quarter of 2025, in 50% of private law cases, neither party was legally represented. And in only 15% of cases, both parties were legally represented. So in 85% of cases, a judge is sitting there with at least one party unrepresented, dealing with some incredibly complex issues, which are being presented in a court of law by a person acting for themselves who is normally totally unfamiliar with the process, what they have to prove, what the evidence is required, all of those things. It is a real concern that people have not got access to justice in these circumstances. And if the government is serious about reducing FORG by 50% over a 10-year period, something presumably has to be done about legal representation in these proceedings.
Well, I think something has to be done about private law. I think that's always the big missing issue. Policies about violence against women and girls, that there's a lot of emphasis on public education. There's a lot of evidence about, school education. There's a lot of emphasis on criminal justice. Family justice is just never there sufficiently. But that's where an awful lot of violence and abuse is both seen on a regular basis and also perpetuated if the court doesn't get it right, or if the court, makes orders that are involving continued contact with abusive parents, then that means that the abuse is going to continue and is going to continue to blight the lives of victim parents and children. So, it always surprises me that family law gets left out of the picture when it's such an important area. The high proportion of litigants in person and, and trying to deal with the fact that they're raising these really complex issues of domestic abuse, I think that there's two kinds of responses to that. So one is to just make it go away, is to ignore it, is to say it's not relevant, it's historic, this is just two bickering parents, it's mutual conflict. So that's one reaction to it, to try to make it go away and to minimise it as far as possible in order for the court not to have to deal with it. The other response is an awful lot of pressure is put on CAFCAS in the situation where there are two litigants in person to sort it out, to essentially become the decision maker as to whether abuse is an issue, the nature of it, whether it's relevant, how it's impacting on the children. And the court is then, very much guided by what is in the safeguarding report or what is in the Section 7 report. And that really should not be the role of CAFCAS, to be the sort of de facto adjudicator in those contexts.
First of all, you expressed a view, Sarah, about the impact of LASPO, and I'd like to say that's not a controversial view anymore. I agree with it. I'm sure Rosemary does. Because don't forget, as one of the parting words of Barbara Mills, our former chair of the Bar Council, she, on behalf of the Bar Council, called for the restoration of legal aid for all parties in the family court system. And I don't use the word family justice system unless I'm using it as a highlight to demonstrate what we don't have. Unless we have access to good quality legal advice for those who are presenting their narratives to the court, there's a danger that children's welfare is going to be lost along the way. Second point is that it was a deflected cost. By the short-term measure of LASPO, all we did was deflect the cost, which became exponentially increased, to the police, to social services, and then in the first instance at the first point of contact of the court and CAFCAS, as Rosemary has just said. So it wasn't a cost saving, it's just exponentially increased the workload of other departments and other budgets. And the third aspect is not to lose sight of the number of clients we have coming to court who are suffering from significant mental health issues, where there are also cultural divides between concepts of understanding about abuse, where there are language issues. And so the obstacles to being heard in the family court system are profound and endemic. which is why I absolutely support the point that Rosemary's made, which is we just don't get airspace for this particularly invidious subject with the politicians. We have expressions of goodwill, but too often they're not followed through by action. And I, for one, am fed up with being told that there's a recognition of the problem because it requires resources, and money talks. And I can't see that money being put into the system. So I think we have to continue to make a lot of noise in order to keep this on the press and public agenda, because ultimately, without being too cynical, that's where the politicians are going to be most influenced. However many reports we churn out for good reason, it's the court of public opinion that's going to make a difference ultimately, which is depressing, I think.
It's also the law of unintended consequences, isn't it, with LASPO? Because, as you said, I think it was designed to save £350 million, and the cost that has been put on other balance sheets from LASPO is probably much more than £350 million. But one of the sort of sticking plasters that was applied was to give anybody who alleged domestic abuse legal aid, subject to having some kind of means requirement to that. And then we've now got this sort of disparity or this suspicion, which you raised in the Everyday Business report, Rosemary, about how sometimes the judiciary perhaps look at recipients of legal aid where allegations of domestic abuse have been made and believe it's a tactical allegation that's giving an advantage. Is that right?
Yeah, I mean, I think that the whole sequels of LASPO has been completely dysfunctional as far as private law proceedings are concerned, because yes, it engenders a suspicion on the part of the judiciary and certainly an accusation on the part of perpetrators that, this is only an allegation that has been raised in order to get legal aid. Also, removing any form of legal aid from alleged perpetrators, I think, is also dysfunctional, because it means that there's no sensible person who understands the law who is interacting with that person and helping them to understand how the court process works and ways in which that they might, that simply denying allegations is not necessarily the best way of enabling them to have a good ongoing relationship with their children. But I think it also, it engenders, greater conflict. It engenders a kind of automatic response of denial or counter allegations, which wouldn't be happening if there were legal representation on both sides. Prior to LASPO, as well as saving money, there was also an anti-lawyer discourse, I have called it, which claimed that lawyers inflamed conflict in the family courts, and therefore getting rid of them would reduce conflict and send more people into mediation, which of course very clearly hasn't happened. And I'm not sure we can even say it was an unintended consequence, because many of us warned that this would happen and knew that it would happen, because all of the research evidence in fact demonstrated that lawyers reduce family conflict and are absolutely invested, and it's in their financial interests as well as anybody else's, to keep cases out of court and to resolve disputes in ways that are as painless as possible for both of the parties. And that taking that away has turned things into what Joe has referred to as the Wild West.
And also I think whether mediation is suitable for many private law proceedings, particularly where you've got coercive control, it's highly questionable.
Yeah.
I'm going to now talk about the framework that we've got, the legal framework. So we've got Direction 12J, we've got the Domestic Abuse Act 2021. Are they fit for purpose? Have we got the framework in place that is fit for purpose for navigating these issues in private law proceedings, particularly in relation to domestic abuse, or does there need to be change?
I mean, I think we do have. We've got the case law, we've got the legal framework, and therefore, in theory, it is fit for purpose, but in practice it's not proving to be so. My issue is on the erratic and unequal quality of understanding about how to use the law as we have it. And it's that lack of consideration and application to the degree that I think should be uniform that leads, in my view, to injustice and therefore a flawed justice system.
Rosemary, what are your views on this?
So I after many years of thinking about this, have come to the conclusion that the law is not fit for purpose. I think that there's two problems with the law. One is that the mixed messages that it sends. So on the one hand, you have PD12J. On the other hand, you have all of the case law that says, you should overturn every stone before you give up on direct contact, the presumption of parental involvement, all of the things that pull in the other direction, and also things like the most recent guidance, which says where you have to take a very rigorous view of whether domestic abuse is relevant, and essentially encouraging courts to find that it's not relevant. And then, on the one hand, you've got judgments like Re-HN, which are very good, but then immediately followed by K&K, which just turns 180 degrees in the opposite direction. So I think that there have been constant mixed messages which result in the kind of uneven implementation that Jo has referred to. But the really fundamental issue that I think is that PD12J asks the court to decide as an initial point whether domestic abuse that's alleged is relevant to any welfare issues that the court might have to decide. Now, I can't conceive of any situation in which domestic abuse would not be relevant to welfare issues related to the child. It's always going to impact on the child. It might be that it's relevant to the way in which contact is conducted or the way in which it's set up. But it might be relevant to whether it should occur at all. It might be relevant to where the child should live. I mean, there are a whole spectrum of ways in which it can be relevant, but I can't conceive of a situation where it would just not be relevant at all. And so I think that inviting the court to decide whether it's relevant is an invitation to minimise domestic abuse, is an invitation to make it go away, particularly in the context that we've been talking about, where the courts are full of litigants in person and have no resources and time. And so my view is that it would be much preferable if PD12J started out by saying the court should determine how domestic abuse is relevant and then take things from there.
So I don't think there's a difference actually with Rosemary, between Rosemary's and mine in terms of our interpretation. It's the base point at which we start from, because like Rosemary, it's difficult to conceive where domestic abuse would not be relevant, because it speaks not just conduct, but a mindset. And so, for example, if one listens to Dr. Jamie Craig when he's talking about how if you are an abusive partner, you can't silo it from the risk that in terms of your concept of relationships, it's going to have an impact on you as a parent. And I subscribe to that view. So the difference between Rosemary and I is, if faced with the question of, is this relevant? I would say yes. It will be a short exercise into how is it? And it takes me back to the primary point I was making, which is, I don't think still there is that degree of uniformity in understanding the ramifications of domestic abuse. I think we've improved it to some extent by the most recent CAFCAS guidance that's come out, which is now properly acknowledging there is no such thing as an irrelevant historic incident. That's probably something to be brought into the equation. And equally, the degree to which now the child's account of their experiences of the home is now to be recorded in the first voice, as indeed that of the victim. So I think we're making improvements, but we're nowhere near where we are. I'm interested in the law being a practical tool. I'm not interested in it being a case law library to look at for generic learning. I want law to be practical and efficient, direct, swift, and just. And that means we need to move into decision making, which requires an analysis sooner rather than later.
Yeah, I think we agree. Unfortunately, what our research demonstrates is that first question about, is domestic abuse relevant? And I think that this is reinforced by the 2022 guidance on the application of PD12J, that what is happening is that the courts are asking whether, and very often they are answering that question no.
And it is one of the problems, perhaps, certainly in Re-HN, arguably there was a tendency for judges at first instance to see domestic abuse very much as mutual hostility, high conflict, and bilateral in its nature, despite the findings that were made in some of those cases. Is that the problem here, is that the default appears to be there are these two people bickering who should know better, who with a little bit of help from the court can resolve this, not there is a controlling person, there is a victim?
Yeah, I mean, I think it's certainly one of the problems, and it's one of the ways in which domestic abuse is persistently minimised or made to go away. Is by, so you might have a set of serious allegations on one part, denial or counter allegations on the other part, which then the default position is to say, oh, this is mutual conflict. And therefore, they just need to get over it and sort it out. So again, in the context of limited resources and in the context of perhaps limited understanding, there is no effort made to determine whether this is an issue of a primary perpetrator, a controlling partner, and defensive responses, or whether it is in fact mutuals. Again, the difference between what we saw in our observations and the way it was talked about in the observations and in the files really demonstrated, that the default to mutual conflict is quite prevalent. I suppose another trope that we find is although the CAFCAS guidance does say you shouldn't dismiss things as historic, that continues to happen every day in the court.
The other issue is just how much time is allowed to the court in order to understand what the scope of the dispute is. If you are sitting in private law, you are sitting in an environment where the sheer volume of cases that you would need to go through to give directions in is almost unimaginable. The reading time permitted for you to get to grips with the file is compromised to an extraordinary degree. It's not unusual when I go to sit that I'll be with people who've been in court since 7:30, 8 a.m. because they are trying to do the pre-reading before the first case is called on at 10 a.m. And that relentless lineup continues all the way through the day, interspersed with ex parte injunctions, which you have to read and get on with. And that's before you've tried to navigate a unreliable case access file system in private law, because there isn't a public law portal. So you're relying on documents being lodged and filed and linked in. The court staff perform the superhuman task to try to assist us when we sit to get access to the papers, but the burdens that they face to get there are just extraordinary. The court staff are real heroes. There are so many obstacles to actually enabling a case to be heard that we don't do ourselves a justice for so long as we continue to defend it. And I think if there was more openness about the fact that the system isn't just breaking but is broken, then we may have a greater recognition about the scale of the problem that we need to address. Because given its prevalence, as Rosemary's demonstrated, if we don't tackle it at its first stages, then we're already failing the children who've been exposed to it, and we've failed the victims. Then we need to address that. But one would far rather have preemptive efforts rather than very poor ad hoc protective efforts after the event, because the harm's already been caused.
Yeah, and that's why in the Harm Panel report we said that the problems here, they're structural and systemic. They're not about any individual. They're not, about people's lack of effort or lack of understanding or lack of trying. And, we do see some people really struggling heroically to try and make a difference, but it is baked into the system.
In the second part of this podcast, we'll be discussing what coercive control is, whether the courts have too high expectations of victims when giving evidence, why, given the prevalence of allegations of domestic abuse, are there relatively so few finding of fact hearings, and whether the future is the Pathfinder process. So please join me, Sarah Ellis, for part 2.